Morning, everyone. This is the second public meeting to obtain public comment for the draft emergency rules and the Vermont homelessness response continuum. This meeting will be recorded and will be available later on the VHRC website. At this point, we have one member of the public attending in person. And we have several folks that are attending virtually. I'm going to give our in-person attendee a chance to provide comment first, and then anyone online that would like to provide comment, if they can raise their hand, I will call you in the order that your hand is raised. Welcome, Jessica.
Thanks, Heidi.
Would you like a chance to?
I think I just cut myself. So I'm just gonna go wash my thing out. Although I really want to hear, it's not bleeding that much. So, is there a Wi-Fi password?
No. Just Burlington Telecom guest.
Heidi, I'm going to raise my hand, but I can't go first because I have to get some kind of device up and working correctly. Okay. So you could put me towards the end. Actually, it's going to take me a while to figure it out. Thanks.
Meeting is being recorded, yes. And so far, no one has raised their hand on the online portion. So when you're ready, are you going to sign on your computer, or I can turn mine towards you?
Still says I'm not connected to the intern, so I might just use yours. It's handle from yesterday's meeting. I could get this to work. No, it's connected. Can people hear me?
Turn to pizza.
I can hear you. Okay.
Hi, everyone. My name is, can you hear me?
Yes.
Okay, great, thanks. My name is Jessica Radbourd, and I'm a senior staff attorney at the ACLU of Vermont. I'm sharing some general comments on behalf of the ACLU of Vermont today, but the majority of our comments will be provided in writing by July 27th. The legislature granted the Agency of Human Services the authority to promulgate emergency rules to implement major provisions of the Vermont homelessness response continuum. The rules involve the most fundamental and basic rights of people experiencing homelessness, the right to shelter and to due process protections. And for people with disabilities, the rules impact their right to be free from discrimination, including their right to have program rules modified so they have equal opportunity to access the continuum services and their right to live in non-segregated settings. These rules really matter. And the voices of people experiencing homelessness really matter. First, I'd like to talk about our concerns related to the lack of adequate opportunities for public input into the emergency rules. The Vermont Administrative Procedure Act requires agencies to maximize the involvement of the public in the development of rules. And in cases of emergency, an agency must provide still whatever notice and hearing the agency finds practicable under the circumstances. An agency's discretion and the level of public input isn't wholly unfettered. That's a finding from the Vermont Supreme Court in Hunter v. State. The agency needs to get more public input. The governor signed Act 143 on June 16th, 2026. On July 23rd, 2026, the ACLU of Vermont submitted a petition signed by more than 25 people, as required by 3 VSA Section 840, to ask the agency to hold hearings on the rule. And it took almost a month for the agency to release a draft of the rules and to schedule public hearings with just 1 day's notice or 2 days' notice in the case of this meeting today. On July 14th, before the agency released a draft of the rules, the ACLU of Vermont sent a 10-page document outlining our concerns related to the anticipated rules that we had not seen yet, and those don't appear to have been incorporated into the draft. Written comments are due on July 27th. To the best of my knowledge, no public notice of this opportunity to comment was provided in the press. The draft rules and the information about how to submit comments are not featured prominently on DCF's website. The department hasn't engaged in direct outreach to impacted people to let them know that their input matters, and it is their well-being and their lives that are at stake here. The agency should expand the opportunity for public input on the draft emergency rules, making sure that it specifically seeks engagement from advocates and service providers and from the people this continuum is meant to serve, our unhoused neighbors. Notices and hearings should be accessible for people with disabilities, and commenters should be advised that public hearings are subject to Vermont's open meeting law and comments are public records. We ask the department to promptly issue a schedule for future hearings and the anticipated dates of release for the remainder of the rules. And again, critically, to incorporate input from people experiencing homelessness, advocates, and service providers. We'll submit detailed written comments, as I mentioned before, on the rules, but for today, I'd like to highlight several problems that stood out to us from our review of the draft rules the agency posted online on Friday. As a matter of law, rules are invalid if they are beyond the authority of the agency, if they are contrary to the intent of the legislature, or if they are arbitrary and irrational. They can also be challenged if adequate process was not provided pursuant to the Vermont Administrative Procedure Act. We're concerned that some of the draft rules appear to exceed the scope of DCF's authority, run counter to the intent of the legislature and Act 143, and don't comply with the Americans with Disabilities Act, the Rehabilitation Act of 1973, the Vermont Public Accommodations Act, and the Common Benefits Clause of the Vermont Constitution. And again, we'll provide detailed feedback in our written comments on the draft rules. Broadly, for now, I'd like to at least highlight that these rules that govern a problem for people experiencing homelessness, appear to remove all agency and self-determination from the people the continuum is supposed to serve. People eligible for continuum benefits are placed in a level of service. They don't have any input, according to the rules, both at the time of their initial assessment and at periodic review. And I trust that people experiencing homelessness know if they would be more successful in a specialized shelter or a low barrier shelter. Not that we fully understand what all of those terms yet, those rules haven't been released yet, but I do believe that people living the experience should be heard and their choices should be supported. We also take issue with the rules that make eligibility dependent on engagement with supportive services. For example, in Part 8, Rule 2.02, it appears that the rule conditions eligibility for an extension of the time limit on shelter on engagement with supportive services, but there is nothing in Act 143, codified as 33 VSA Section 2212B, authorizing such a requirement. We're also concerned about equity in the system. Vermont's Constitution prohibits arbitrary and irrational classifications. That includes arbitrary classifications based on geography. The draft rules imply that an eligible household could be denied benefits solely based on the luck of geography or staffing levels, and that's not acceptable. Lastly, we're very concerned about accessibility in the system for people with disabilities. Rules, including the time limits, must be modified to ensure that people with disabilities aren't subjected to disparate treatment or put at serious risk of harm to their health. And because people with disabilities have a right to live in integrated environments, they can't be forced to choose between unsheltered homelessness and institutional care or other segregated settings. We're concerned that the rules don't reflect the known needs of people with disabilities, the affirmative duty to accommodate people with disabilities when their needs are known, when we know that over half of the people experiencing homelessness in Vermont have disabilities. And we're concerned that the rules don't reflect the rights of people with disabilities to live in community with other Vermonters, with all of us. I'm going off script because I believe so strongly in how important it is to hear from the people who are living the experience. I know that this continuum is not going to solve homelessness in the state of Vermont. We have 4,299 people experiencing homelessness. We have around 1,200 shelter beds. We are capping the use of motel rooms for shelter at around 700 rooms, going up to 1,000 in the winter, which means that a lot of people are going to be outside. And I can tell stories, and other advocates can tell stories about having an 11-year-old child look them in the face and beg for help because they don't want to sleep outside anymore. Or all the fair hearing decisions that I've read of people with significant disabilities who are literally begging for their lives because they know they're going to die outside. But I think you don't need to hear that from me. The agency needs to hear that from those people to give them a chance to be treated like they actually matter. As I mentioned earlier, we'll follow up with more detailed comments by the 27th and hope to have additional opportunities to provide feedback before the rules are implemented on September 1. Thank you.
Thank you, Jessica. We've had a few more people join in person. As of right now, we only have one person online with their hand raised, so I'll let the folks in the room have an opportunity to comment.
I'll just say again.
Oh, if you could come up and, so we had some issues yesterday with people hearing. So I'll just turn the.
Hello, Deanna Hartog, Vermont Legal Aid. I did give my comments yesterday, so I'm just here listening in, but wanted folks to know that I'm in the room. Thanks.
Did anyone else attending want to provide public comment? Okay.
Hello, Ian Horn, Civic and Community Engagement Advocate at Disability Rights Vermont. We're the federally designated protection advocacy organization for the state, as well as the designated mental health care ombudsman under 18 VSA section 7259. I just want to echo a bit what what Jessica mentioned about ensuring choice for people accessing services, for people with disabilities, to make sure they are able to receive services in integrated settings. And I wanted to hone in a little specifically about Part 10 of the rules, specifically the criteria for termination. The rule determining suitable placements should be more firmly defined to exclude institutional settings such as nursing and inpatient psychiatric facilities, in line with the Olmsted case, to ensure that people with disabilities can receive, services and care in the most integrated, least restrictive settings. And also with supportive services, this was something that was specifically struck from the bill by the Senate Committee on Health and Welfare, as these were removed from the eligibility requirements in committee. These should not be added back in through rulemaking. It conflicts with existing law, 18 VSA section 7629, which affirmed that it was the intent of the General Assembly to allow a legally competent person to make their decision on medication and medical treatment absent an emergency. So the rules should more clearly define both that institutional placements are not suitable placements, and also ensuring autonomy and agency for those receiving services to make their own determination as to receive treatment or other services. Thank you. And thank you for the opportunity to speak.
Thank you, Ian. Does anyone else in the room want to provide comment? Okay, then I will turn to the folks online. Brenda, are you ready to go, or Megan Lesage has her hand raised?
I think there's people who can go before me and I'm not ready.
Okay. Megan, would you like to provide public comment?
Sure, yeah. I have to sneak out early, so that would be great if I could do mine now. My name is Megan Lesage. I am a former senior benefit specialist with the Economic Services Division. I'm submitting this comment to that capacity. Before I say anything else, I do just want to say that the notice for this comment period was not adequate. A week is not enough time for anybody to read 40 pages of law and cross-reference it against a new set of rules, let alone for the people that these rules will actually affect. An example, people living outside right now, people this whole trajectory is supposed to serve people that do not have a mailing address to receive a notice at, people that do not have reliable internet to find this hearing, and people that may need support to even figure out how to actually comment on a rule that will decide whether they have a place to sleep. If you actually wanted to hear from the people living this reality, you would give them more than a week. Right now, you're not hearing from them. That should really worry everybody, honestly. I spent years as a senior benefit specialist for economic services. I was assigned to work with an organization that helps people with disabilities get past the exact kind of overly complicated hurdles that keep eligible people from getting help that they do qualify for. That assignment was some of the most important work that I have done. I watched people who absolutely qualified for services get turned away over and over and over again, not because they weren't eligible, but because the rules were written to be rigid instead of workable. I've watched what happens when a system is built that way, and some of those people lost their lives. I'm not saying that just to be dramatic, but I'm just saying it because I watched it happen, and I don't want to keep watching it happen. This is the first year that I have been able to follow a law as it moved through the legislature, start to finish. So I know what the legislature intended when they passed Act 143. They intended a continuum that meets people where they're at and gets them into permanent housing. What I'm reading in these drafted rules is not that. What I'm reading is a set of rules that make it harder to get in that door, harder to stay once you're in, and harder to get back in if you're put out. That's not what the legislature asked for, and I want this department to hear that clearly from somebody who spent my entire career talking directly to these people and the people that it affects from inside the department. These drafted rules do not reflect legislative intent. I'll also be submitting a written comment before the deadline with more details, so today I'm just highlighting a few of those areas. I want to walk through a few specifics just because generalities, oh my gosh, I can't talk today, sorry, won't move anybody. Let's see. Proving that you're homeless should not be humiliating. These drafted rules make it humiliating. Part 3 of these drafted rules put self-attestation last on the list for verifying homelessness. It says that the department should try third-party verification first, then staff observation, and only that will they take a person's own word for it. Think about what that means for somebody standing in front of a caseworker with nowhere to sleep tonight. Who exactly is that third party? Who verifies that a person is homeless? A landlord that had evicted them, a police officer, or in my worst case scenario, what about somebody who just left an abusive partner who can't go back there? The only person you could verify that isn't at home anymore is the person that they're fleeing. You can't default to a domestic violence agency as a fallback either, because not every agency serves every person who needs it. For a lot of people, there's no third party. There's just them telling the truth about their own life and being made to feel like their word isn't good enough until somebody can confirm it. I processed applications for years. I watched people go through this. It's not paperwork. It's not a paperwork inconvenience. It's a humiliating experience that tells somebody in crisis that they're not trusted, right when they most need to feel like the system is on their side. That is the opposite of what a front door to housing should feel like. Self-attestation for disability is gone, and that is a direct reversal of what the law requires. Act 143 says flat out in the statute itself that a household can self-attest to a disability, subject to follow-up verification within 30 days. This was a real hard-won protection. These draft rules do not include it. For prioritized group status, the rule only accepts a letter from a licensed provider or a determination from a state or federal disability program. I spent years helping people navigate exactly this kind of documentation requirement. Getting doctor's appointment in this state can take weeks. People with disabilities, especially that are undiagnosed or newly acquired, they often can't get that paperwork on demand. It takes a very long process. Dropping self-attestation does not make the process more accurate. It makes it much slower, and it punishes the people who most need the support that the law had promised them. Access to a motel room has been narrowed past what the law allows. The law says that if a household's needs can't be met by prevention, shelter, or specialized shelter services, and a room is available, that they can be placed in a hotel or a motel. That's it. These draft rules add a requirement that isn't in the statute. The household also has to belong to a prioritized group. That means a person who is eligible under the law, who has nowhere else to go, and who a room is available for, can still be turned away because they don't check one of 6 boxes. That is not what the statute says. That is the agency writing itself a narrower program than the legislature created. These draft rules lean on an assessment score that nobody has seen. Let's see. I just lost my thought. Section 2.2 and 4.01 of Part 8 both condition how long somebody can stay and whether they can get an extension on having an assessment score of X, not just a number, just the letter X. Left blank in the draft, the public is being asked to comment on. Act 143 does not rely solely on an assessment for these decisions. It certainly does not rely on a score. The department has not told anybody what that score even is. If this department wants a real assessment, it should be built with organizations who do these intakes every day, like the one I work for now. I'll go into more detail on this in my written comment. Forcing people into treatment as a price of keeping their housing is harmful, and the law does not allow it. Act 143 does not permit forced treatment. That was carefully and deliberately discussed when the law was written. These draft rules say a household shall be terminated for not engaging in supportive services, without the protection the legislature built in. Forcing somebody into treatment under threat of losing their housing does not work. It backfires. I have seen it backfire. The 12-month lockout after termination is not something this agency had the authority to write, and it goes further than even the law's own list of reasons. The only place Act 143 talks about reinstatement is one line. The department shall adopt rules for and I quote, a process for reinstatement of services after a household's termination from the program. A process, not a waiting period, not a penalty. These draft rules turn that single sentence into a flat 12-month period of ineligibility on ever coming back into the program. That is a substantive penalty this agency was never given the authority to create. And practically speaking, it means someone who makes one mistake or has had one bad accident is locked out of emergency housing for a full year. A year of exactly the kind of unsheltered homelessness this whole law was written to eliminate. We have already seen what even a 30-day period of ineligibility can do to somebody with nowhere to go. Imagine what 365 days will do. It's inhumane. I want to close where I started. These rules read like they were built to make it hard to get help, not easy. They read like they're designed to punish people for the circumstances that brought them into this program instead of meeting them where they are and walking them towards permanent housing, which is what Act 143 actually asked for. I know what it looks like when a system does that. I know what it costs, and I'm asking this department to send these draft rules back and have them rewritten to match the law the legislature actually passed. Thank you.
Thank you, Megan. We've had some new people join online and in person, so I just wanted to restate that if you are online and would like to provide comment, raise your hand, and I'll call you in the order that your hand is raised.
Hi, I'm Beverly Boget from the Vermont Early Childhood Advocacy Alliance.
And will you be interested in providing spoken? Okay.
No, thank you.
Okay.
Is there just any way you could either make that louder or turn that around so we could hear it better?
I can turn it around.
Okay.
All right, so up next, Shelby LeBaron, are you ready to provide comment?
Sorry, I think I got it. Yes, I can.
Thank you.
Okay. My name is Shelby LeBaron. I'm submitting this comment because I used to be a client of this system myself. I will also be submitting a written comment before the deadline that has more detail. So today I'm just highlighting a few things. I want to say something about the timing of this comment period before I get into anything else. A week is not enough time. I know that firsthand for reasons I'll explain in a moment. There was no week in my life during the crisis that brought me to this system where I had the time, the phone battery, or a clear head to do something like read a set of draft rules and figure out how to respond to them. Families going through that same kind of crisis right now do not have a week to give. If you want their voice in this record, a week is not going to get it for you. And certainly this time frame for the public comment packed into a single meeting or two was not enough time either. I found the support I needed while I was being exited from the hotel program. I was in labor at the time with a high-risk pregnancy. My baby was born prematurely and needed in-home nursing support. I also live with disabilities myself. Thankfully, my family stayed safe and I became permanently housed because the support that was there when I needed it. I don't know what I would have done or what would have happened to my baby if we hadn't stayed sheltered. I wouldn't be sitting here today with a healthy child and a stable home if the support hadn't been there. I want to talk first about what happens when a disability and a medical crisis show up at the exact same moment a household is trying to get help, because that's exactly what happened to me. Then I want to go through the same problems in these draft rules that others have raised, because I ran into every one of those too. So the first being verification requirements assume a calm moment that a lot of families never get. These draft rules ask for verification of pregnancy from a healthcare provider and verification of disability from a provider or state agency. I was in labor when I needed help. There was no calm moment where I got to sit down with a provider and got a form filled out before I needed shelter or to keep my shelter. There was no warning. Crises and paperwork don't happen on the same schedule. A rule that assumes they do is going to miss the people who need it the most urgently and not the people who need it least. Self-attestation for disability has also been left out, and it would have mattered to me. The law says a household can self-attest to a disability subject to follow-up verification within 30 days. These draft rules drop that for prioritized group status and only accept a letter from a provider or a state agency determination. I live with disabilities myself. I was also trying to keep a premature newborn alive and get us both somewhere safe. Getting a formal letter from a provider was not something I had room for in that moment. Self-attestation exists for exactly that kind of situation I was in, and these draft rules take it away. The short authorization windows do not match how a medical crisis actually unfolds, and the law never asked for them. Part 8 of these draft rules authorizes hotel and motel placement in chunks, 7 days, 14 days, 28 days at a time, with reauthorization period required at the end of each chunk of time. Nothing in Act 143 creates these short authorization windows. The law sets a 70-day limit and a set of extension criteria. It doesn't say anyone has to be reapproved every week or 2 weeks along the way. This is something that the department added on its own. My baby's care did not run in 7-day increments. In-home nursing, specialist appointment, emergencies, and a premature infant's needs do not resolve on a schedule that fits a rule's authorization periods. Every time a family in a situation like mine has to be reassessed and reauthorized, that is one more moment where something could be missed, one more form that has to be right, one more chance for a family already on the edge to fall through. Access to a motel room has been narrowed past what the law allows. And the law says that if a household's needs can't be met by prevention, shelter, or specialized shelter services and a room is available, they can be placed in a hotel or motel. That's it. These draft rules add a requirement that isn't in the statute. The household also has to belong to a prioritized group. I qualified because I was pregnant and then had a newborn. But I think about all the families whose need is just as real and just as urgent, who don't happen to check one of those 6 boxes. That is not what the statute says, and it is not what should decide whether a family gets a room. The 12-month period of ineligibility after termination goes well beyond what the law authorized. The only place Act 143 talks about reinstatement is one line. The department shall adopt rules for a process of reinstatement, not a penalty. These draft rules turn that into a flat 12-month period of ineligibility. We already see the harm that periods of ineligibility cause when they're only 30 days. It is quite clear that the legislator never intended for a penalty this harsh, leaving people outside for 12 months to exist. For a family like mine, that kind of lockout at the wrong moment, it isn't a technicality. It's the difference between a baby staying safe and a baby's life ending. My daughters are both healthy today because I got support that helped me navigate a system that was not designed to match the crisis my family was having. Labor doesn't wait for paperwork. A premature baby does not wait for a 7-day authorization window to end. If these draft rules had been the ones in place when I showed up in the middle of that, I don't know what I would have gotten as a result. I'm asking this department to go back and rewrite these rules so they actually match the law the legislator passed, because rules written the right way could have helped my family, not just avoiding harming us. A good system meets people where they are. It's flexible but not rigid, and makes sure there's no wrong door. That is what I know the legislator intended. These rules have a lot of wrong doors. Thank you.
Thank you, Shelby. Teresa Wood, you're up next. Are you ready?
Hi, good evening. Yes, I'm ready. I think that the first thing I want to say is I agree with a lot of what the previous commenters have said. And for the record, my name is Teresa Wood, and I'm chair of the House Human Services Committee that originated this bill in the legislature. So I guess I would say, overall, there are certainly elements of these draft emergency rules that, comply with the intent of the statute. But there are definitely areas that do not comply with the intent of the statute. And there are things that are left out that seem to be important, like that the ADA applies to the whole statute and the whole process, not just an appeal process, for instance, that being one. And I'll agree with folks that, I know that you're trying to comply with a September 1st emergency rule requirement date that's in the statute. I get that. But really 1 working day's notice of the initial availability of this, and then the initial hearing yesterday, and then just a week for people to make written comments, I think doesn't really speak to the ability of people, whether it's anybody who have participated on these calls or in the hearing, or people with lived experience, to be able to actually provide any kind of meaningful input. So that is really important. I find when I went through these, and I just have only read them in the last hour or so, so I'm sure that I'm going to find other things, but I find things like in section 3, department or community shall verify homelessness or risk of homelessness as follows, listed in order of preference. There is no order of preference listed in the statute. These things are listed, but they are all of equal volition. In other words, there is not, there's no intent that one should be ahead of the other, you know, whether it's third-party verification or observation or self-attestation. It was never the intent, and it is not set up that way in statute. I do find it odd, and again, I'll just agree with what folks have said about the dropping of self-attestation. I'm going to, you know, cut you some slack and think that maybe you've put this in the wrong place and you really meant this to apply to everything. But it should be under disability as well. I also find it odd that this doesn't speak to level 1 services at all, which is around prevention. And it seems as though just ignoring that doesn't make sense to me. And maybe that will be coming out in the next version. I'm not sure. The reference to the assessment and the assessment score and looking for extensions and talking about a score. It's hard to tell what the assessment is. I don't know if that is meaning the coordinated entry assessment or if that's meaning some separate assessment that the department is going to develop. I know there was some discussion about, we had originally talked about the coordinated entry assessment, and some folks didn't agree with that. So I think it would be helpful to have more specificity around that. The authorization periods in section 4.01 is, I'm just going to say, blatantly not in keeping with legislative intent, period. I would not foresee these being approved in this manner if they continue to be submitted in this manner. There was no intent that there was going to be assessment, reassessment, re-looking at this. The whole concept is that if you have a case manager, that they're going to be in touch with you on a regular basis and they're going to be assisting you through this process. There doesn't need to be this superfluous reassessment and reauthorization process, you know, for, you know, whatever you have here, 7 days, 14 days, 28 days. That is not the intent of the legislature. In section 2.0 of part 9, talking about periodic review every 30 days. Okay, the whole concept behind this is that folks will have an active case manager / service coordinator, and that they will participate in a housing plan. So if that's actually happening, and that's what's supposed to happen, then this is just an added administrative review that is really not necessary. Certainly the case management entity, whether that's a community organization or some other state department, there should be a mechanism to, you know, inform DCF if there has been a change in status. But just requiring this superfluous administrative paperwork seems to be really redundant in my perspective. What it feels like is that you're trying to fit the sort of like old version of you know, quote unquote hotel program into what the new statute says. And I think people at the department know that that really is not the intent at all. I agree around the application for reinstatement. You know, a year. I mean, this is inhumane, frankly. And I'm very, very disturbed to see some of these things, to be honest. And then there's specific things like, you know, and a household is presumed to have received the written notice 3 days after the date on the notice. Okay, so I don't know about the rest of you, but I can receive something 2 weeks after somebody mailed it. And relying on the mail service, that certainly is sketchy these days. Never mind the fact that somebody may not have an address that they are able to send that to. And I've already talked about accessibility. That is not just for hotels and motels. That is for all aspects of this program. And I'm sure there are going to be other things that I have to comment on, but that was it for right now. You know, like I said, I appreciate the timeframes that you're trying to deal with. But I just find it odd that you've chosen certain things to include word for word almost from the law, and then totally, you know, didn't address some other various things. So I hope that we see a new and revised version of this as we move through the process. Thank you.
Thank you, Teresa. We have Tamara Hodge. Are you ready to provide comment?
Yes, I'm here. Okay, my name is Tamara Hodge. I'm submitting this comment because I used to be a client of this same system myself. My children and I were in the hotel program not that long ago. I will also be submitting a written comment before the deadline with more detail. So today I'm just going to go over a few things. I wanted to start with the comment period because I don't think that this department truly understands what a week actually means for someone in the position that I too used to be in. When I was homeless, I didn't have a week of anything. I didn't have a week where I knew where I'd be sleeping with my kids, or a week of the kind of clear-headed time that it takes to read a rule, understand it, and figure out how it affects you, and then to write something down about it. If this rule had been open for comment while I was still in the program, I wouldn't have been able to comment on it. Not because I didn't care, but because surviving the day was literally the only thing that I had room for with 3 children. If the people this rule is actually about can't comment on it, then this department isn't really asking the public, are they? It's asking the people who have time, which is the opposite of who needs to be heard here. I have a disability too. And for a long time, that disability was the reason that I kept failing at the process. Not because I didn't want help, but because I couldn't access it the way that the system expected me to. I missed appointments that I couldn't get to. I didn't respond to letters I couldn't process in time. To almost everyone looking at my file, that looked like refusal. It looked like non-compliance, when what it actually was my disability. I was one of the people this whole continuum is supposed to catch, and instead I kept falling through. The only reason I made it to permanent housing and the only reason that I have the career I have now is because End Homelessness Vermont was the one place that understood the difference between someone who won't and someone who can't. I had other supports in my life, but this was the only place that addressed what I actually needed and fully acknowledged my disability. That is why these draft rules worry me so much. I'm not reading them as any type of policy type person. I'm reading them as someone who used to be the person on the other end of every one of these sections. Dropping self-attestation for disability would hurt people who don't have another way in. The law says a person can self-attest to a disability and get verified later within 30 days. These draft rules take that away for prioritized group status and only accept a letter from a provider or a state agency determination. I think about the people that I live next to in the hotel who didn't have children, whose only path to prioritized status was their disability, and who didn't have a diagnosis letter sitting in a folder ready to hand over for someone's confirmation. Getting that documentation takes appointments and follow through, a phone that isn't dead, the exact things a disability and a housing crisis take away from you at the exact same time. For them, this rule doesn't just add paperwork and more of that feeling of never doing enough and yet feeling like you're not getting anywhere at all. It really removes the only door that they have. A full year locked out after a termination like that would have ended differently for me. The law only gave the department authority to write a process for reinstatement, not a punishment. These draft rules turn that into a flat 12-month period of ineligibility, and it's not allowed. It applies to the same kind of non-compliance that used to get pinned on me for reasons that were never actually my fault. I got a second chance because the system I finally found let me back in. A year-long lockout does not give anyone that second chance. It just makes sure that they're still out there a year later if they survive, and we have seen so many who haven't made it. An undefined assessment score is not an assessment. These draft rules gate people's length of stay and extensions on an assessment score of X, and the department hasn't said what that even is. When someone sat with me and actually figured out what I needed, that took listening, not a placeholder variable in a rule nobody has explained. If the department wants an assessment that works, it needs to be built with the people it's actually meant to help, not handed down without us. I am living proof that when this system meets someone where they are, it works. I got into permanent housing, and now I have a real career that makes me so happy every day. My family is stable, and we're all doing really well. So many times along the way, I almost lost my shelter because of rigid rules that were inhumane. These draft rules would have made it a lot less likely that I'm the one standing here today instead of still out there. I'm asking the department to go back and rewrite these rules to match the law the legislator actually passed, one that was built to bring people in and not keep them out. Thank you so much.
Thank you, Tamara. Would anyone else online like to provide comment?
I will, but I cannot find my hand.
Okay, there's someone in person that would like to provide comment,
Okay,
so
we'll
I
have
can
them
let them
then
go
go
first. Okay.
Thank you. By way of introduction, I'm Representative Doug Bishop of Colchester, and along with Representative Wood, my chair, I serve on House Human Services. I don't want to take much time because I think I would be reiterating much of what has been said, but I think it's important to reinforce and echo what Chair Wood said this evening so that the department has a clear sense that additional members who sat on the committee that worked on this for months also are seeing great deviation from the intent, legislative intent in several areas, and an absence of certain things, additions of others. So I simply wanted to primarily reinforce with another added perspective of a representative who was part of pulling this legislation together, that we're seeing those differences. I also wanted to reinforce the many very good points that have been made by others this evening about where those deviations exist. And with respect to the timeline, if in the very short timeline, few people who were able to contribute to this evening's comments were able to find this number of deviations, I think it highlights that a broader scope perspective, broader group of people to offer perspective would, I'm certain, surface additional areas where there's deviations and where there is room and need for changes and improvement in these draft rules. There are many specific things I could probably go into, but there was a reference to the timelines for the criteria of termination. Most of the termination periods are 10 days, but you have 14 days to request a hearing. That starts 3 days, presumed 3 days. You've received it, so is that actually 17 days? How does this timing work? Someone's 10 days can run, yet they haven't had the full amount of time to request their fair hearing, where their benefits could therefore be continued while that grievance is being heard. So again, thank you for the opportunity to speak and for having the opportunity for others to speak as well. And I hope that there is an opportunity, additional opportunity for more to chime in on this very important set of interim rules. Thank you.
Thank you. Brenda, if you're not ready, someone named Katie has their hand raised.
That's fine.
Katie.
Hi, good afternoon. I'm Katie Tormey. Sorry, my last name wasn't up there. I am a parent of a young adult with a developmental disability. I'm also a member of the Developmental Disabilities Housing Initiative, DDHI. We are a parent of Vermont parent-run advocacy group with over 185 families as members. We support the development of stable, service-supported peer residences for our adult children who have an intellectual and developmental disability diagnosis and qualify for Medicaid home and community-based services, waivers, and have significant support needs. We're asking that the Department of Children and Families, Department of Disabilities, Aging, and Independent Living allocate 50 state-funded rental assistance vouchers for adults with IDD in the emergency rules decisions. Other Agency of Human Service populations receive state-funded rental assistance, and we are asking for equitable treatment for our adults with IDD. Individuals with IDD are at a high risk of homelessness as we elderly parents become unable to care for them. These adults have limited financial means and cannot move into housing without rental subsidies. Ongoing and pending housing projects for this population cannot move forward without the assurance of rental assistance. While we understand people exiting homelessness are an important population, the intent of the House Human Services Bill H938 highlights that adults with IDD are a population equal in priority. Our adult children are the most vulnerable members of our community and cannot access coordinated entry because if left homeless, will perish. So they continue to be housed in hospitals, institutions, etc. Thanks for your consideration.
Thank you. No one else online has their hand raised. Brenda, are you ready to provide comment?
Yeah, I'm just gonna have to wing it mostly.
Okay.
First of all, I want to just introduce myself. For the record, I'm Brenda Siegel, the Executive Director of End Homelessness Vermont. I want to begin with the process itself because it shapes everything that follows. Notice of this public meeting was given with only 1 business day's notice, then adjusted to for 2 for this meeting. Even setting the meeting notice aside, the comment period, the written comment period that runs 1 week is not long enough. I recognize the department is working with a tight statutory timeline, and I don't say this to minimize that constraint, but many of the people this rule will govern need meaningful support just to engage with a process like this one at all, let alone to read a technical rule, understand what it changes, and respond within a week. A timeline this short makes it functionally impossible for people currently experiencing homelessness to participate in a meaningful way, even though they are the population most directly affected by what this department decides. And I will just say that with my own disability, I have not been able to thoroughly read and compare the rule, and I am not experiencing homelessness. I also want to flag a broader concern before I go into specifics. Several pieces of this draft rule appear to be appear to reach outside of the department's jurisdiction under the statute and in ways that track proposals the legislature specifically discussed and declined to adopt during the drafting act of Act 143. Coerced participation in treatment is an example. Restrictions on hotel and motel eligibility beyond what the statute sets. That the legislature specifically did not create different eligibility for the hotels, and the rules do. Limits on household self-determination, that there was specific self-determination. The legislature considered these approaches and chose not to write them into law. It chose instead a system that's meant to meet people where they are and have a right door for everyone. I'll go into more detail on each of these in my written comment, but I want the department to hear directly that this pattern feels not incidental. And I want to just say also that periods of ineligibility have been discussed over the years, and the legislature did not include periods of ineligibility. And now it's not 30 days, but it's 12 months. And I would say that periods of ineligibility are not what the statute allowed. I want to walk through 4 specific places where the draft rule departs from the statute and that it was meant to implement. And there's going to be several other areas, but I feel with the time we have today and with my ability at the moment, I'm just going to focus on 4 areas. The draft rule shrinks who can even get into a motel room, as I said, beyond what the law allows. Act 143, Section 22076 says that any eligible household whose needs can't be met by levels 1 through 3 may be placed in a hotel or motel if capacity allows. Full stop. No additional gate. This draft rule at Part 8 Part 1 adds a gate anyway. Level 4 is available only to households that belong to a prioritized group. That is the agency writing a restriction the legislature did not put there. A household that doesn't fall into one of the 6 prioritized categories, someone over 65, a person with a disability, a person with a minor child, a pregnant person, a survivor of domestic violence or trafficking, or someone who under court-ordered eviction can be shut out of a motel placement entirely under this draft, even with no shelter bed available or rooms sitting and a room sitting empty. Of everything else in this draft, this is one of the clearest cases where the rule exceeds what the statute actually says. The draft rule quietly deletes self-attestation for disability, something advocates, including us, fought to secure in the statute, and the legislature was very clear on. Act 143-2211 lists 3 acceptable ways to verify disability for prioritized group status, including self-attestation, subject to verification within 30 days. This draft in Part 3 lists only 2, a licensed healthcare provider or a state federal agency determination. Self-attestation is gone. For a household that can't get a doctor's note fast enough, that is a difference between being prioritized and not, and it contradicts the statute's plain text language. And I will just say that I did ask about this when we first saw them, when first told about this meeting, and the answer was nothing will change before Monday. I didn't get a clear answer. The draft rule adds an undefined gatekeeping score that the law never created, and it isn't even filled in. So that's in Part 8. It governs extensions to the 70-day limit, and it governs an initial authorization, but both condition on an assessment score of X, left as a literal placeholder with no number given. I understand this isn't complete, but it's impossible to comment on that without it being complete. 3 of the 4 statutory extension grounds get this bolted on threshold requirements and that don't exist in statute beyond the substance published and beyond the substance. Publishing an emergency rule with the actual eligibility standards left blank is a due process problem, and even in draft, and no one, including the household that governs the rule, can be told whether they qualify. And I do want to just say really clearly that you can't decide what the need is of somebody based on an assessment score. working with individuals living with disabilities, which is my entire life's work, and at this point, my own existence, is something where you work directly with them, you learn about them, and it is based on a human interaction between a case manager and the individual, not based on an assessment score. No self-respecting case manager or self-respecting clinician bases anything completely on an assessment score. Verification of homelessness itself is structured to make self-attestation a last resort, not a first option. Part 3 of the draft lists third-party verification first, staff observation second, and self-attestation last. As you heard Chair Wood say, these were not put in priority, and in fact, in my memory, and I'll have to review the statute, I'm not sure that verification of homelessness was a requirement for the program. There were other verifications there were other areas where verification was. For many applicants, there's no third party who can attest to homelessness, and requiring someone to exhaust other verification methods before their own word counts at the exact moment they're asking for help does not make an eligibility determination more accurate. It makes the front door harder to get through for the population this program exists to serve. And I will just say that when there used to be verifications of homelessness several years ago, we worked with clients who were kicked out of their homes because they had come out as in the LGBTQ community, and then the department had to call their families, and was one of the most damaging and humiliating experiences for them to verify their homelessness. This is not a healthy way to approach this program. The 12-month period of ineligibility, as I stated before, following termination exceeds the rulemaking authority that the legislature was granted. The only provision in Act 143 addressing reinstatement said, and I quote, "a process for reinstatement of services after a household's termination from the program." That's a process. The authority was to write a process, not to write a categorical waiting period. The draft rule turns that single sentence into a flat 12-month bar, and it applies only to households termination. It applies only to certain households, or it applies beyond the statute of how you're even allowed to be exited from the program. A substantive penalty of that scale applied grounds the statute itself into a punitive statute. It is not something that this rulemaking authority supports. It's not something that the statute supports, and it is not helpful to getting people into permanent housing and working with people and meeting them where they are. I want to close by naming what ties all of this together. Each of these is, on its own, a serious policy concern. And more than that, each one is not within the law. Taken together, they point to something more specific. These draft rules do not just implement Act 143, they narrow it. Level 4 placement is limited to households in a prioritized group when the statute allows it for any household a room cannot be found for, or who cannot be served by the rest of the program, is the language of the statute. Self-attestation for disability, which the law requires the department to accept subject to later verification, has been left out. Extensions and authorization periods are tied to assessment scores that the department has not defined anywhere for anyone and doesn't follow best practice. And the reinstatement provisions turn into a single sentence authorization of a process into a penalty. The verification requirement deserve particular attention because they set the tone for everything that follows. The draft asks households to prove their own homelessness through third-party verification or staff observation, as I said, and there's several other very intensive verification requirements in these rules. Verification exists to protect the integrity of this program. It should not exist to make the program harder to reach than the crisis is meant to address. I say all of this respecting the work that went into standing up a continuum this complex on the timeline the legislature set. This is not an easy task, and I'm not trying to underestimate it. But respecting that effort is exactly why I'm asking the department to take the time to align this rule with the statute it implements and with the intent behind it. A system that meets people where they are, not one that asks them to clear a set of hurdles the law itself never built. I would welcome the opportunity to work with the department, as I've offered several times, on getting there. Thank you very much.
Thank you. Is there anyone else online or in person who would like to provide comment? Not seeing any other hands raised. The meeting will be open until 7 if anyone chooses to come forward to provide comment.
I ask you some questions, follow up from yesterday.
You can. I may not be able to answer them.
Some of the concerns raised at yesterday's hearings were similar to today around the timing of this process and getting more public input. Does the department have any feedback on the input received yesterday and again today on when we'll see drafts of the remaining sections of the rules and what sort of further opportunities for comment?
No, I don't have any information on that.
I have a question as well on process. I'm curious that no one else from the department is here. I'm not sure if anyone else from the department is online. I didn't notice you taking a lot of notes. I'm curious about how you're tracking the input and how you'll be giving that, I'm also curious about, did you write these and did you have help from any policy person at the state in writing these?
Yes. Teresa Wood asked if people speaking could please identify themselves. The meeting is being recorded and the recording and a transcript of the recording will be available online. And there is a group of department staff who are working to draft the rules.
You can indicate that it was Beverly that was speaking.
Beverly just gave that comment.
And the first person to ask a question was Jessica Radbourd from the ACLU of Vermont. And in addition to the recordings, written comments will also be posted online with sensitive personal information removed, correct?
Mm-hmm.
And so, this is Beverly again. Were you write these rules or who in the department wrote the rules?
There is a group of department staff who are writing the rules.
And are any of them people that followed the legislative process?
Yes.
Can you identify who led the process?
Our commissioner, Sandy Hoffman, leads the implementation group meetings.
Thank you.
I meant to say this before, so I'll just say it now. If you're sorry, I'm a little, I guess, astounded, though not surprised, that that the department hasn't met with those of us that provide these services in implementing such a serious program. It seems like we were asked for our housing plan templates, but we were not met with. And I know that many of us offered. I know that Chad made the same statement yesterday from HHAV, and it just seems like I think we all want the same thing, which is success in getting people housed. And if you want success in getting people housed, the experts who do that really should be the people who work with the people with disabilities on the ground. The people who are there every single day need to be part of how this program is run. It cannot be run in that same bureaucratic way that the GA program was run. It is that there's so much adversarial nature, there's so many fair hearings, and this is just setting up the same exact system. And I'm telling you, it's setting up the same problems.
Yes.
Hey, folks. Nice to see many of you again. This is Jonathan Farrell, the Executive Director at COTS. I did make a few comments last night. I may repeat some, but we'll also add just a few, and we'll also provide written comment. One, to reiterate, as many of you had said, the timeline for this process is very compressed in the summer and difficult for all of us to meet. Secondly, the rules mention a screening criteria, and very much in this set of draft rules depends upon that tool. So I'm curious as to when it will be discussed and reviewed with service providers. I'm curious about who administers the application process that is mentioned in the rules. And I'm also very curious about who creates the individualized needs assessment and what the input process will look like for that. How will scores be determined for level of service? What sort of input from service providers and guests will be provided for that? And then what better methods might we use than assessment scores? Assessment scores prove very problematic in other systems such as coordinated entry. Lastly, time limits. I think this is a very pressing issue. We are seeing 72 families in Chittenden County alone that are on wait list for shelters. And of those 72, that's unduplicated between two providers. Of those 72 families, 31 of those families are experiencing unsheltered homelessness. This is a long time for us to wait until September 1, when we have kiddos sleeping in our community in places not meant for human habitation. Thank you.
Taylor Tebow, you have your hand raised. Would you like to provide comment?
Yes, please. Thank you. I'll just be brief. I just wanted to thank you for the opportunity to provide feedback on the draft rules. And before I begin, I'd also like to note that I plan to submit formal written comments with more extensive feedback and detailed recommendation following today's forum. I have one question and suggestion for future rulemaking processes. And as someone who is directly involved in implementing these policies on the ground, I would appreciate hearing a brief overview of the stakeholder process that informed these draft rules, specifically like what themes or recommendations emerged from their working group, how those recommendations were evaluated, and how they ultimately shaped the final draft version. I recognize that significant work went into developing these rules, and I think providing that context would help participants better understand the rationale behind those proposed changes. It would also make the process feel a little bit more transparent and inclusive for providers and community partners who are not a part of drafting the rules or the drafting process in general, and but who will be responsible for implementing them. And yeah, just wanted to share that feedback, and I appreciate again your time and the opportunity to participate today.
Thank you, Taylor. There's a comment in the chat from Brenda Siegel, clarifying question. You said it was just department staff, correct, not stakeholders. It is just department staff involved in the implementation sessions.
I have a quick clarifying question, I guess. When you say that the staff of the department will be implementing it, which staff is that referring to?
It's department staff from Economic Services Division and the Office of Economic Opportunity.
Okay. Interesting. Okay, thank you.
Is the emergency rule process, is it required to go to LCAR at all?
Yes, the emergency rules are effective upon filing with the Secretary of State and LCAR. And then LCAR does vote to approve or object to the rule.
And since these are due by September 1st, does that mean you're going to give them to LCAR on September 1st?
They will be filed with the Secretary of State and LCAR no later than September 1st, and then heard at LCAR's next available meeting after September 1st.
More that providers in the field have time to implement that issue that are in effect the day you issue them.
I don't see Lily Sojourner on the call, but she would best be able to answer that. For a lot of the shelter services, because those grant agreements are already in place for this fiscal year, those requirements won't be changing. The hotels, we have contracts with 2 hotels, I believe, but I can't really speak to that.
Sorry, could you repeat the ACLU of Vermont? Could you repeat what you just said about some things not applying to shelter providers?
So the grant agreements are already in effect for this fiscal year, so they will be following whatever requirements are in place in their agreements. And the rules, I expect, would reflect that they are to follow those agreements for fiscal year 27. And then for the implementation of the permanent rules, October 1st, that's when new program requirements may go into effect.
So following back up on my previous question, this is Beverly Bogat. We'll chat it out the state lines. So you spoke about the fact that about the impact of the rules going into effect on September 1st on providers that were shelter providers. What is the impact of the other providers like community action agencies that provide case management services to people that are receiving services, and the coordinated entry system and the others that provide case management?
I can't speak to that.
Has there been any conversation in your rulemaking group about how the communication of this change in rules would go to people that are receiving services and to organizations like 2-in-1 that have to direct people to those services, to where to get information about the services?
I would have to get back to them. Oh, there's Sandy. She can-
Sorry, I've been on. I just want to make sure that this is just public comment for the rules, right? Like, I don't know if that was set out. That's what this session is.
So not Q&A.
No, it's not a Q&A. If you do have, I can answer some clarifying questions, but not a Q&A.
I suppose we could take all my comments and make them into statements. It would be helpful if there was a process, it was clear process about how the communications were to happen for providers beyond shelter providers.
That'd be great feedback. And we'll respond to everything.
Again, this is Jessica Radford from the ACLU of Vermont. I think both for when certain requirements apply to shelter providers, other service providers, the office, it would be helpful to do a close review of what's in Act 143 and make sure that the rules in
Had someone join the meeting with via phone. I'd like to give that person an opportunity.
That's just Sandy.
Oh, okay.
It got disconnected, so I called in.
Okay.
Thank you.
I think I just have one more quick comment to add. Um, can everybody hear me okay? Can anybody hear me?
Can hear you. You can go ahead.
Oh, okay. Sorry, I couldn't tell. I had to switch over to my device, so I just wanted to make sure. But I just wanted to say that it's really scary to just see rules that might make this harder to serve people from this aspect. So I'm hoping that everybody's comments that they've made today are taken seriously, because it's really hard from this side of the fence to think about how things are going to progress forward for all of our clients, and I know many other agencies' clients as well. So I just wanted to add that into my comment as well.
Hey Heidi, it's Taylor. Um, can everyone hear me? I guess I'm still here. I'm just like I'm trying to read the draft rules like while simultaneously listening to folks' testimony, and I just thought since I was still here, I would share like some targeted themes that I've seen throughout kind of reading through the rules, and I've only gone through the first three parts. Um, but as I was, what I thought would be like helpful and clarifying during this meeting is just as I was reading through, I would encourage the department to recognize that successful engagement in housing stabilization is a shared responsibility um, between households and the homelessness response system itself throughout Part 8 in particular. So, level 4 services or remote health services. There's continued eligibility for level 4 services conditioned on household engagement with case management, completion of housing plan activities, and verification by a case manager. And while these expectations are understandable, the rules place comparatively little emphasis on the responsibility of the service system to ensure that these supports are actually available to people. Successful participation in housing planning depends upon timely access to qualified case managers, reasonable caseloads, consistent communication, sufficient community resources. And in many areas of Vermont, providers continue to experience workforce shortages, vacant positions, high staff turnover, limited service capacity. And these challenges may delay assessments, housing plan development, documentation, referrals, follow-up through no fault of the household seeking assistance. So I would recommend that the rules explicitly recognize situations in which a household is unable to fully engage because services were unavailable, they were delayed, or otherwise inaccessible. In these circumstances, households should not lose eligibility for continued shelter assistance because of system limitations beyond their control. And I would encourage the department to incorporate language recognizing that extension decisions should consider both household participation and the availability and accessibility of services required under the housing plan. I feel like this approach better reflects the reality of the homelessness response systems and ensures that households are not disproportionately impacted by staffing shortages, provider vacancies, or implementation challenges during the rollout of this program itself, the Vermont Homelessness Response Continuum. And then finally, just recommending that the department define what constitute engagement with housing stabilization services. Like establishing a clear statewide expectation would promote consistency across providers, reduce subjectivity in extension decisions, ensure households are evaluated equitably regardless of where they access their service. This decision should also recognize, and I think a lot of folks have said this tonight, that engagement may look different depending on a household's circumstances and should account for barriers outside of the household's control, including provider capacity, transportation, health, disability, caregiving responsibilities, and other factors that may affect a participant in the program.
Taylor?
I just want to say that I completely agree with what Taylor's saying, but also just understanding that there is thousands of case managers across the state of Vermont, and they're not going to be within the umbrellas that I think they're counting right now. I know personally that our organization has had a lot of trouble helping our clients get verified due to staffing shortages, and our clients are staying very engaged with us, but again, just having that clear standard of what is considered and who can be considered, and understanding that there is multiple agencies in the state of Vermont that are providing these things. And it might not fit the bill of what, people that don't deal with this every day understand, but just understanding that these clients are working really hard, and whoever's available to help them, they're going to use those people first, because that's their option because they're outside.
I was going to suggest this in a written comment, but since we're sitting here in silence, I will suggest it now. And we've just been talking about that extension period time. We work with a lot of clients that would qualify under those categories, since we work primarily with people living with disabilities. And I want to just make the suggestion in the rules that I think I stated that it can't be done by an assessment score. I think it really does need to be, first of all, trusting a case manager and trusting a person so that they can reach out and say, hey, this person does meet this category, this is why they meet it, and not having it be based on an arbitrary score, because I think that is going to lead to serious problems. And so I think that I agree with the consistency, but also with the just understanding that engagement for many people might look much, much, much different. And we'll give some examples I will give some examples in End Homelessness Vermont's written comments. But giving one today, we have someone who's going to be housed. We're really excited about that. They declined this particular housing option several times. It took almost a month of working with them to get through their own disability and fear and things, and they are accepting it. But that under these rules, they would have been kept out because they couldn't get beyond the piece that that was blocking them, the barriers that were making them afraid. And so I think that that's really important to understand the lived experience of people who are helping folks and people who are housed, that you heard from some who are now housed today, but also people who are experiencing homelessness and what barriers they have faced. I think that that's we have a lot of people really scared right now with very significant disabilities who are going outside, who are outside, and whom, will probably, some of them will have catastrophic outcomes. So that's what we see every time. So hopefully this system really, really takes into account that these are not by number. These are these are human interactions that make these, that help to determine these factors.
I just want to make a comment real quick. I just wanted to say that I agree with Taylor in that before I found a case manager that understood my needs, I couldn't move forward. And once I did, things really started like progressing quickly for me after that. So I really hope that this continuum will include all those who provide housing navigation. I just know that a lot of people are left out right now. So just wanted that out there.
Tamara.
I guess I just wanted to say one last thing before everyone goes. This is Shelby again. I thank everyone for the really, really good comments that were given tonight. I know I've seen a lot of people housed in the past months, and that's awesome. We've also seen a lot of people die. So I really hope all the comments given are really heard tonight. Thank you.
Thanks, Shelby. And thank you everyone for taking the time to provide comment. It's now 7 o'clock. I'm going to close the meeting. It will be available later on the VHRC website.
Thank you.